Hey everyone, it's RobbRyder. This is Sunday, February 1st, 2015. We're talking about an issue of court security, it being Exhibit A, and some paperwork that said the clerk of the court shall send file stamp copy of this order and the attached Exhibit A on some documents that happened this last couple of weeks in court, and we're going to see if we can piece together what's going on. And I have another story to tell you that is along the same lines, so I'm just going to tell you the story. And then we're going to look at just a bunch of little pieces of things we're going to try in other court cases and interesting things you might want to go FOIA, because it would be good evidence for when we figure out the right door to go to take the information to. If you got all that. We're talking about a lot of different things, in other words. Nothing really deep, just kind of blowing through a bunch of things. But a couple of them are really of interest that we're going to spend quite a bit of time on. So, but in the meantime, if you could, please donate. It's February 1st, 2015, and I can't pay my rent. You could use PayPal, Ashley, Ritluski, gmail.com, or snail mail to me, 10955, 14 Mile Road, Rockford, Michigan, 49341. So why don't you just pause for a second, and if you would, write those down, and if you get something out of these things I do, please send a few bucks. I could really use it. I don't want to harp on it, but yeah, I got to eat. Okay, so what happened? What happened? Well, let's go back to what happened in the phone call I had with a brother named George in Virginia, who lives up on a mountain someplace. His power's off of a extension cord, and he does everything off of his telephone. Doesn't have a computer. The reason he can do that is he was born on, what do you say? A solar eclipse. Maybe that's why he can do those kind of things. Right? I need a computer with all this information, and he's doing it off a telephone. Nevertheless, he had called me back in September or something. He had been stopped on like the Blue Ridge Parkway or one of these federal roads. Traffic ticket, federal court. Boom. So I think he had a little weed on him. I don't know if that's what they got him for or not. Anyways, traffic ticket. And so you're talking about it, and I had asked him at the time, I said, well, did the cop sign the ticket? And of course he hadn't, and I've talked about this numerous times in other videos. I mean, there's always an error someplace. Either they were not using the form that's been prescribed by the whoever. Usually it's the Supreme Court that says, here's the form, this is what you shall use, and that's not what they're using. Right? So who do you take that to? Who does that complaint go to? Or the form is correct and they're doing something wrong. Like, they're not signing with their full name. They're using Officer Smith, and that isn't going to cut it. You only have one proper person, and if you want to be seen as a witness, you got to use your proper person. So, anyways, he had written up an affidavit, and he put it in the court case, and I believe he submitted those tickets, and I think as he told me, he wrote right on the ticket that the cop hadn't signed the ticket. Well, he's doing this on the day of court, and then he goes to court, and he gets handed a order to pay $400 and some in fines. Okay, well, he had an answer for that too. He was going to flip it over in the back and write 12 USC something or other, blah, 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 blah. Take it to the clerk's office and say, here, I want to take care of this now. And gave it to the clerk, and the clerk looked at it. She went and made a copy and gave him the copy and kept the original. And he went home. Right? So this is back in October. So now here, a week or so ago, he gets a letter in the mail from the court that says that his court case has been closed. Right? Not dismissed, closed. Court case is closed. And we're returning you your exhibit. And inside the file is the affidavit that he wrote with the sticker on it indicating that it had been put in an evidence file. Now, George is going to send me a copy of this, right? But like I said, he lives on a mountain, with an extension cord. So he's got to go, get it scanned and blah, 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 blah. So I'm waiting for it, but if George said it, I'm sure that's what it is. The question is, did him writing on the back of an order from the judge something about 12 USC, and that's going to pay the debt, and giving it to the clerk, did that close the court case? Or did he put in evidence that, hey, the cop didn't sign the frickin' ticket and this is a simulated legal process using color of law? All right, civil rights violation. I don't even know what he wrote. That's why I need to see I don't want to say too much because I don't know what he put in his affidavit. We'll just wait and see. But what I do know is when they sent it back to him, it had an exhibit sticker on it. So it got put in as evidence. I'm going to say that's what did it. And I'm going to base some of that on what I'm going to show you right now, what's going on in Roe's case. Where Roe just got... This was just this week. In the Circuit Court of the 16th Judicial Circuit, Kane County, Illinois. And please keep, before we go any further, there's a of and there's a for in her case, right? You could see some that say Circuit Court for the 16th Judicial, Circuit Court for the 16th Judicial, or Circuit Court of the 16th Judicial. The of is, the smaller of the two. It's the one that's in the 16th Judicial, and the for is the one that's over the 16th Judicial Circuit. And this is the of. This is the smaller of the two. This is not a court of record. Right? There's no clerk here. There's no reporter. But in this court that's not a court of record, they still put this order in. So this is the one you usually find yourself in. Again, this should have been for disorderly conduct, misdemeanor, $35. However, when they took Roe in, they had nothing to do with that. It had everything to do with getting her to sign a piece of paper that's supposed to be like a bond, but it isn't, because it isn't the proper form. They call it, when they talk about it in court, they call it the certificate of defendant. And sure enough, there's a place where it says certificate of defendant where Roe signed her name. And when you read what it says, it just made you indebted to this entity that isn't really the government for X amount of dollars. Right? Now you have an obligation with them. And that's what you're going to go to court for not paying your frickin' debt. And they're going to take you to this lower court that has jurisdiction in these matters by statute. But in this case, matter comes to court on a motion for discharge hearing based on Public Act 98. Right? They didn't use the statute number. Now we're talking public acts. Court grants motion. Matter continued to 3/18/15, 1 p.m. in KBC for discharge hearing. Chief Judge Office to provide court reporter on 3/18/15. So on that day there will be somebody here in this court reporter box, and I bet you they have a deputy clerk show up on that day too. Because we're not talking statutes anymore, we're talking public acts. Right? We changed the head of the court, in my opinion. And that was all based on, now, so this just happened this week. Well, 2 weeks ago when she was in court, and she had a bunch of cops in there that day, sheriff's officers lying in the wall. The prosecution had asked for in-treatment care. On the stand was a guy named Ray, who's a clinical psychologist at whoever does this stuff for the government, Department of Human Resources, at DHS, I guess it is. And so the judge asked him, well, she, do you think she's a threat? And he said, well, no, she's not a threat, of course, right? And he said, I could give her outpatient care still, right? So they sat down and talked for 3 hours that day. And Ray put in some paperwork, but we had put in some paperwork, and now instead of having this inpatient treatment, being taken off to the psycho ward, they want to have a discharge hearing. And a discharge hearing is a bench trial. And in the bench trial, the judge determines the fact and the law. And in this particular discharge hearing, the very first thing that has to happen is finally the prosecutor has to bring forward the claim. This is where at the stage where evidence can be entered into the court case, and up until now there's been no evidence. Right? I guess that's what I'm trying to get at. And so this happened on 1/28/15, so just last week. And while we're not really sure, so Roe went down to look at the court case to see what had been put in the court case, and what she found that she hadn't expected to find was there was also an order from the chief judge. And because Roe didn't have any money with her and she couldn't get a copy of it, she hand wrote it. And I said, well, you got to type it up for me. So she did. So we can't pay any attention to the cases or the case of the words and so forth, but just what it says. Because this had been put on 12/15/2014, so over a month ago. But I don't believe it shows up on the docket when you look at it online. It doesn't show up. But it was an order put in by the judge, the chief judge, that said this cause coming on for administrative review of ex parte correspondence concerning the above numbered cases. I asked, did it say S's? And she said, yep. Dated December 10th, 2014, addressed to the attention of the undersigned chief judge and received on December 12th. Said review conducted pursuant to policy and procedure. This court having reviewed the correspondence and the court file finds blah 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 blah. We'll get to that in a minute, but this is the hugest paragraph you could ever read. This court having reviewed the correspondence, right? Conducted pursuant to policy and procedure. In other words, she really didn't do Roe a favor. She did it because it's the procedure. We had asked in effect for a review, and we got one. No, we didn't. At this stage, we weren't saying take judicial notice, and we're asking for judicial review, writ of certiorari. No, but I believe that we could go here now after what I'm seeing and say, okay, Judge, we're going to change it, and we're going to say this, this, and this instead of what we did say. Nevertheless, the judge did an administrative review of the case, conducted pursuant to policy and procedure. This court had reviewed the correspondence and the court file finds. So they looked at the court file also, because that's what the correspondence said to do. Defendant having been found unfit on the 28th, 2014, that the ex parte correspondence dated December 10th is relevant on the issue of the defendant's fitness and on the issue of court security. And we're not talking about people standing in front of the doors of the cops against the wall. No, go read the definition of security. In fact, we will shortly a little bit of it. It's all about bonds and financial instruments of one kind or another, or somebody having a duty. So, anyways, wherefore it is hereby ordered, the clerk of the court shall file the ex parte correspondence, which we'll look at in a minute, dated the 10th of 2014 of December, and attached to this order as Exhibit A in the court file. So a copy of the order, a copy of what Roe sent, going to be called Exhibit A and put into the court file. Shit, man, that sounds to me like that's evidence. The clerk of the court shall send a file stamped copy of this order and attach Exhibit A to DHS, Kane County SA, Defendant Stoskaveen, Kane County PD, Acting Director of Sheriff Court Security. Couple things. Roe never got a copy. So now we're going to say, hey, what address do you have for this defendant? Because it didn't say Stoskaveen, Rosita, just Stoskaveen. And that goes back to that being your full name and their society. If you look at the last video I did, and I'm showing these marriage certificates and how they had them filled out, where you look at your passport, your surname sits by itself. And to them, that is your full name. That's like the military. What's your name? Your last name. That is your name. You don't have a first name. That's what they tell you. Duh. That is the jurisdiction you find yourself in now. We want to get out of that jurisdiction. But that's what she said, defendant Stoskavine. So Roe never got a copy of this order to her. And the director of sheriff court security. Now, I believe this means a court called the sheriff court, because the sheriff is not the 10-star sheriff. The sheriff is the king's top businessman in the shire. And right, so this is the smaller court that's not a court of record, the one that's in or of the 16th Judicial, not for the 16th Judicial. Okay, so anyways, court security, issues of court security, and so all these people were supposed to get a letter and a copy of this information, well, evidence, Exhibit A, and that's where it sits. So we don't, now in the court case that Roe's looking at, she didn't see, right, the rest of the exhibit, which was her correspondence and the exhibits that we sent. There was just this order. But this clearly says to put everything together, staple it together, and put it in a court file. And it clearly said that there was cases, and we've known that there's more than one case going on here. They use, the numbering system is a little bit different. They may put like 2015 in one and 15 in another, right? And then the two numbers, or I mean the two-letter designator, and then maybe not have zeros to start in one and have it in the other one. And so they're running and they run next to each other in parallel. The inferior court that isn't part of the state system, and the superior court that is. And we can see that here in just a second, but let's look at security really quick. So security, the term usually applied to an obligation, pledge, mortgage, deposit, lien, etc. given by a debtor in order to assure the payment or performance of his debt by furnishing the creditor with a resource to be used in case of failure in the principal obligation. Document that indicates evidence of indebtedness, the name also sometimes given to one who becomes surety or grantor for another. And I think that's what the chief judge just became, the surety of Roski. Absolutely. Good job, Roe. Test for security is whether the scheme involves an investment of money in a common enterprise with profits to come solely from the efforts of others, so that whenever an investor relinquishes control over his funds and submits their control to another for the purpose and hopeful expectation of deriving profits therefrom, he is in fact investing his funds in a security. All that to say, right, that somebody put up their bond to bring this case that said, we're going to get Roe's property without Roe knowing how he did it, and we're going to make it look like it's a criminal case, but it's never going to leave the civil division, and this is the scheme. Schemes are never good. And, you know, you can have voting trust certificate as a security, and I think that's one of the things we have is, I don't trust anybody else to vote for me. I didn't ask for anybody to vote for me. I want to vote for myself. Cost. So security for cost. Payment into court in the form of cash, property, or bond by a plaintiff or an appellant to secure the payment of cost if such person does not prevail. In Blackstone's days, they called it trial by wager. Right? Somebody's put up their money to say, we're going to take your property and you're not going to know how we did it. Ha 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 ha. And we're going to make it look like you committed a crime. We're going to make it look like it's your fault. That's how we're going to do it. We're going to make it look like it's your fault. Because they're never going to get to the stage where anybody had to put in any evidence. But once you have them take judicial notice of the adjudicative facts and law of the case, well, now they have to look at the evidence. Okay, so enough on that. We're moving on. Okay, before we look at what we put in, let's just look at amity real quick, right? Because The federal courts derive their exclusive jurisdiction over this field from the Judiciary Act of 1789 and from Articles 3, Section 2 of the U.S. Constitution. So the federal courts have jurisdiction in admiralty. These courts functioned separately from courts of law and equity. They didn't used to be in the same place as law and equity. So admiralty law in the United States developed from the British admiralty courts present in most of the American colonies. These courts function separately from courts of law and equity. With the Judiciary Act, though, Congress placed admiralty under the jurisdiction of the federal district courts. And so the federal district court has jurisdiction in law, equity, and admiralty, and we need to get him into the right hat. And I think that this court here is the inferior federal court that Roe is in right now. It's actually a federal court. Although admiralty shares much in common with civil law, which is equity, it is separate from it. Common law does not act as binding precedent on admiralty courts, but it and other law may be used when no law on point is available. So you get to point out whatever law you want to, even if it's a bad law. If somebody else doesn't, right? If you don't know what they're doing, it doesn't matter what they point out. Parties subject to admiralty may not contract out of admiralty jurisdiction. The states may not infringe an admiralty jurisdiction either, judicially or legislatively. Since admiralty courts, however, are courts of limited jurisdiction, the Savings and Suitors Clause does provide for concurrent state jurisdiction so that non-admiralty remedies will not be foreclosed. Moreover, state court may have jurisdiction where the matter is primarily local. There you go. So they got you in this admiralty jurisdiction. But the state court has concurrent jurisdiction for non-admiralty remedies. Well, that would be equity, right? But you need to get over there because they got you in this one here, and we needed to get into the other one. And so, whatever that means exactly, like take judicial notice, if that's what it comes down to, well, then that's what we're going to try. This also applies to criminal laws governing the ship's crew. I don't know if that means anything with what we're doing, but this is the big thing right here, that parties subject to admiralty may not contract out. States may not infringe, that's the biggest thing, on admiralty jurisdiction, either judicially or legislatively. So when they come to foreclose on you, on your house, right, they're coming to collect a debt. It isn't about the real property, it's about an indebtedness. And if they can make it look like that indebtedness had anything to do with a contract on the water, then they can enforce it in the state courts, and the state courts have to enforce it for them. I've got an admiralty lien, enforce it. And that, these were rules that were made up because they said, well, what if the guy gets on land? He's going to get away from us. We need to arrest the property, arrest the vessel, arrest the captain. Okay, so this is what we had put in. So all this is all really about this right here. So here it is, December 10th, 2014. Circuit Court of Illinois. There is one Circuit Court of Illinois, Circuit Court of Illinois, 60th Judicial Circuit. So the Circuit Court 4 is the Circuit Court of Illinois. Kane County, Geneva. Okay, so we had found that anyways, we had found this by looking at enough paperwork eventually online for all the different ways you could call the court. And, PDFs start showing up, and if you take the time to open and look at them and read what they say, you say, hey, this is what they're calling the court. So we said, forgive me, I'm not sure of your lawful title. It appears on ARDC, which is the Attorney Registry Disciplinary Committee, that Judith Mary Brokaw is a full license name of an individual attorney authorized to practice law within Illinois, who is now also holding the office of Chief Judge of a judicial circuit under the assumed name of Judith M. Brokaw. So do you understand what I'm saying? On her license is her full name, Judith Mary Brokaw, but she's in this office as Judy M. Brokaw. Well, if you know anything about being a judge, to be a judge, you need to be licensed to practice law, and the middle initial name was never licensed to practice law, so she really can't be a judge. Right? So the one with the full licensed name is now holding the office of Chief Judge, Judicial Circuit, under the assumed name of, right? So she's using an assumed name, basically. Is it lawful to hold two offices under different names? How is it that Judith M. Brelko, who was never an attorney and could not have been elected or appointed a judge, have you vacated your office and merely usurped its powers? Yeah, when I wrote this, I didn't write very good. I said, Ro, here's an example. She sent it out. It's like, oh, that wasn't quite done yet. I have to look closer next time. Nevertheless, you and those like you participate in Conference of Chief Circuit Judges. Among other things, this conference approves the forms used in Circuit Court of Illinois. Right? So in Illinois, they have this conference, and they decide what forms are used in the court. Further, it appears that you have been appointed to govern the courts and practice of law by rules of your private society within a defined territory, namely the 16th Judicial Circuit Court of Illinois, of the Circuit Court of Illinois. Really hard way of saying. Okay, so they approve the forms, and she was appointed by she's elected by the other circuit judges within the circuit, elect who's going to be the chief judge. And I don't know how long they hold the office for. 2 years, longer, what the deal is, right? But somebody's appointed the chief judge, and the chief judge is there to administer the courts. So they don't really sit in court. They administer the courts. And so, we went for an administrative review and got one. So anyways, I'm sorry to have to inform you that your subordinate officers of court, fellow members of your private society, right, members of the bar, bound by your rules, members of the bar rules, the rules that say that the Supreme Court governs the practice of law within the state of Illinois, and here's the rules. And if you break those, you're in contempt of the Supreme Court of Illinois. Bound by your rules, are habitually using unapproved forms in your court, rendering the proceedings not only illegitimate, and it is an indirect criminal contempt, but also nothing less than an international crime against humanity. Jeepers, Ro. I told you I wasn't done with this yet when you sent it. I'm blaming Ro for my own writing, but anyways, you get the idea. Forgetting how shittily it's written, they still said, hey, evidence. We're pointing out, here's your forms, and they're unapproved, right? So that makes everything they're doing illegitimate, and it's indirect criminal contempt of court. So you're pointing out the fact in the law. Right? I don't need to point out to them anything clearer that if you violate what the Supreme Court says, then you're in contempt of the Supreme Court. They understand that. I don't need to go find the law. I just tell them. That's common law. According to the Illinois Supreme Court Rule 552 in pertinent part, but we will, because we'll just go find their rule. Uniform citation and complaint forms and conservation complaints shall, you just got to love the word shall, there is no way around it, shall be in forms which may from time to time be approved by the Conference of Chief Circuit Judges and filed with this court. The uniform forms shall be adapted for use by municipalities. And so when we went and looked at what they're using today and looked at what they used against Roe, well, it's obvious it's not the same form. They're in contempt of Supreme Court Rule 552. But who are you going to tell? Well, we sent it to the chief judge in the mail, and she said, hey, that's ex-parte, and let's make it an exhibit. There must be something to do in that. I am providing you documentary evidence of an unapproved uniform citation and complaint form that was filed in your court under gen number. Right? So what Roe did is she went to the sheriff's department and said, I want a copy of the complaint that was filed against me on whatever date, and they gave her a copy of theirs. And on the one that she got from then, it said gen number whatever. On the one that's in the court case, it doesn't have gen number whatever. They covered that up and they put something else on there. Now, the only reason that's even in the court case is because Roe went and got this one from the sheriff's department and bitched about it not being in her court case, in court, and they went and put it in. But they didn't put this one in. They doctored up the numbers on it. I mean, it's just, again, it'll be more evidence. But who do you point it out to? And that's where we're at. Who do we take it to? We took it to the chief judge. Anyways, see Exhibit A. The use of this unapproved uniform citation and complaint form is in direct criminal contempt of the Illinois Supreme Court, and the officers involved have brought fraud upon said court by participating in an official misconduct and false personation of a public officer. It is the will of the Lord that you make them stop now. So when I was writing this, I had in my head, I was thinking about the Bible. I said, what did Jesus say? He told the widow he talked about the widow that kept going to the chief judge until the chief judge gave her justice, right? So I was thinking along those lines. We'll just point out what they're doing wrong. And judge, this is what's going wrong in your court, right? The use of color of law in a simulated legal process is a civil rights violation, and the enforced disappearance of my person is considered enslavement because they don't have you in your proper persona, right? If I go to court, it's not as Robert Allen Rytlewski, it's as Rytlewski, Robert Allen. That's the jurisdiction of United States of America. We want to be in the United States of America, but we need to go over the style. I believe gen number is a simulated legal process using color of law, as is the unapproved bail bond form and the unapproved arrest warrant. Some other rules here, right? Unauthorized practice of law, multi-jurisdictional practice of law, and Rule 8.3, reporting professional misconduct. I see this is the one that really gets them. Rule 8.3, in whatever the attorney's professional conduct manual is, wherever you're at. They could call it professional conduct. Right here it's called Article 8, Illinois Rules of Professional Conduct of 2010. Rule 8.3, reporting professional misconduct. If you point out to another attorney that an attorney is committing misconduct, well, now they're on the hook to turn them in. Right? It's a twofer. Point it out. Rule 8.3. Taken together, make it dereliction of duty for one Judith Mary Brokaw, authorized attorney and counsel at law, not to prosecute these violators. I made her responsible. Make it dereliction of duty for one Judith Mary Brokaw, authorized attorney and counselor at law, not to prosecute these violators. Because the attorneys and the judges involved aren't using the name that's on their license. So they're involved in the unauthorized practice of law or official misconduct. Right? It's not a judge, because there's no judge that could have been with a middle initial according to the rules. Right? It needs to be an attorney authorized to practice law, and that's the name that's on their attorney license, for lack of a better term, and in most cases it's their full name. So that's catching the chip. You, Judith Mary Brokaw, are responsible for their behavior, and it is the will of the Lord that you make them stop now. Judith Mary Brokaw, why do you persecute me? I have provided you evidence of my citizenship in the kingdom of heaven in the form of my baptismal certificate. I do not consent to a presumed jurisdiction over my property or myself. I do demand you enforce your private society laws over those who have freely consented to your jurisdiction. Right? If they're attorneys in the bar, they volunteered. If you somehow feel you have lawful authority over me, then you must immediately inform Vatican City State of my request that they represent me in this matter. I appeal to Sovereign Pontiff Francis. See that he is informed. Hey, it's an exhibit, right? Get the Pope on the phone. Pope Francis, Roe would really like you to give her a call. Some good Catholic hit that in the Pope's ear. I'm sure he would do it. For the record, I am an immortal spirit child of God, here as one of his people, who has chosen the state of life as a citizen of the Holy See and freely given the Catholic Church in personam jurisdiction over my persons. Bravo! Good enough. Roe was okay with that. Okay, so we put this in, and the judge made it an exhibit and put it into a court case. And where it goes from here, we don't know, because we've done a few things since this. Because again, this never mentioned. It was called a letter complaint to the chief judge, right? What if we had said, take judicial notice of request for judicial review? Because she did, she called it an administrative review, which is okay, but there is a judicial review, and that's when you do a writ of certiorari, and then the court actually renders a decision. Right now, this is an administrative side; it isn't in the court. That's how it works in the. So, if you want to writ a certiorari, federal level, you would go to the Solicitor General, because he's learning the law, and you would ask him, "Hey, can you get me a review? Can you look at this case and tell me if it should be reviewed?" Because the upper court has an obligation to supervise the lower court. It's part of their supervisory mandate. So if you send a court case, examples of what's in a court case, to a man learned in the law, he's going to be able to say, hey, this isn't lawful. We need to look at the court case. And again, so on the federal level, when they prosecute you in the United States of America, well, that's not the government. It's the United States of America. And we're going to look at that in just a second. But anyway, so this is what, all this was the driving force behind getting this issue of court security out of a chief judge. And we'll see what happens next. Okay, hang on. Alrighty, before we go look at what we're doing in a couple other cases, another thing that it may be of interest to you to try. This is what Roe did, right? We were looking to find some information about, on a FOIA, basically, the name of the Kane County Criminal Division Chief and all county officers who are commissioned by the governor. Because in the old, in the original Constitution, it said that how did it put it? That all judicial officers were commissioned by the governor, and that county officers were commissioned by the governor. I believe that's what it said. Anyways, got us to ask the questions, and we wanted to know who the chief prosecutor for the criminal division of the county court was. And I'll show you that reason for that in just a second here, but real quick, just so I can show you that there is two different courts. If you look at this, it says on the top line, it says in the circuit court of the 16th Judicial Circuit, Kane County. And the next one down is in the circuit court for the 16th Judicial Circuit, Kane County. Those are two different courts, right? And so this is out of like the legal paperwork or legal paper for the county, Tri-Cities Republican. So go find your legal paper and look at the names of the courts and see if there's a difference. And if there is, well, then there are two different courts. Right? Start there. Identify there's two different courts. Then figure out which one is which. The one you can find all the paperwork for is going to be the inferior court, like the county court. And the one that there's very little paperwork to find is going to be the superior court or the state court that has concurrent jurisdiction with this lower inferior court. So, okay, and I want to look at one other thing here, if I can find it real quick. Because this was, Kane County State's Attorney. Okay, Kane County State's Attorney's Office. Look at how this is set up. This is why we were looking for the criminal prosecutor. Structure. Under criminal, traffic, misdemeanor, so forth, so on. And you think that you're going into a misdemeanor case, right? Because in Roe's case, it was supposed to be disorderly conduct. Should be a misdemeanor. So it should be under criminal. But look what's under civil. Kane County, right? So Kane, Kane County. Well, who wrote the ticket? Well, the Kane County Sheriff did. Kane County. And the mental health court. And what were they trying her for, right? For mental health evaluation. So while you think, this is where the simulated legal process comes in. You think you're being picked up for a crime by the state or by a government entity, but you're just being tried down here in the civil because you signed a piece of paper when they had you sitting in the jail holding cell, so you can't leave until you sign that piece of paper. And on Roe's, it was called the certificate of defendant on a piece of paper that looks like it should be for their bail bond stuff, which said that she was indebted to a particular entity for $1,500. Right? So now it's a money issue. It's no longer a crime as far as the $35 fine that there should be for disorderly conduct. No, they're going after a $1,500 lien they have against you that they get in this civil court, and then they're going to take it to the state court and get them to enforce it for them. Because you can never point out that, hey, they may have it, right? So they have this. So now from the civil, well, we have a lien against you, and the common law says, well, if there's a lien against you, then you're guilty. We're going to take your property. So you can't go to the common law because they have a lien against you from another court. It says it right here. Can't go to the common law. The common law is going to go with what the order says. So you have to get the hat switched over to equity to say, even though they have this order that says that I owe them $1,500, they got it by fraud. Oh, well, that's different. Well, okay, now we can do something for you. That's the court of equity. So what we want to do is we want to go find the guy that's over the misdemeanors. And the main reason for that, until proved different, is this started with looking for the guy called the Solicitor General. And in Georgia, they have a guy called the Solicitor General, and he is the guy that prosecutes misdemeanors. Okay, well, that's what we're trying to point out, a misdemeanor. Real quick, before I forget, when Roe was on Friday, so she went to court, to the civil court building on Friday, because they have an area in the court where attorneys sit, and you can come and ask them questions. It's the whole idea, right? So she went there to ask some questions, and one of the questions she asked was, well, what do I do if somebody's may have been involved in the unauthorized practice of law? And the attorney said, oh, man, that's a crime, right? You need to take that to the criminal division of the prosecutor's office. Excellent. So, yeah, that is a place to take it. We didn't tell him it was another attorney. But he, a lot of his... but a lot of the questions she wanted him to answer, he couldn't answer. He said, well, it sounds like you have a criminal matter, and I'm a civil attorney. I do civil. There are criminal attorneys, and you can reach one, and he had the information for her to get a hold of one, but he wasn't one, and he wasn't going to play the game. Okay, so again, just this whole thing is right now we're down here in your court case. You think you're in traffic or misdemeanor. You're not. You're in the county for a indebtedness, and they're going to try to put you in a mental health court because you won't play their game. And so your only choice is to get it back up in here into this criminal court. And I think this is what the chief judge is over now, because now it is in the criminal side, on the state side, who had concurrent jurisdiction, and they do look at evidence, and they have certain rules they follow, and that's where we're trying to get it to. Again, the chief judge didn't. She said it was policy and procedures why she was doing this. It was her job to do it. Okay. But anyways, back to this request. Your request is granted as follows. So here we go. Right now, they're going to give us the names of the bureau chiefs. Right, felony is William. Right, so we can email all three of these guys. Yeah, three guys. Yeah, they're all three guys. Yep. And then your request is granted as follows. Secretary of State's qualification for county officers, 2014 and close. Please note, it's the Secretary of State that issues, not the governor. Issues commissions, not the governor, because we were asking about commissions. Commission, because one of them is that the state's attorney has to be commissioned. Well, when you look at this, now this is where, this has nothing to do with the stuff we were talking about. It's just interesting because it will mean something someday. This is the qualifications of county officers, and it came from the state's attorney's office or the prosecutor's office. I don't know that you couldn't get this just going to whoever the normal FOIA person is, but it would be worth asking for qualifications of the county officers. Because this tells you what every officer has to have. The auditor has to have a bond, an oath, file with the county clerk, and a certificate of qualifications issued by the clerk. Then, to get the commission issued by the Secretary of State, they have to have sent the certificate of qualifications and a $2 fee. Well, they're not holding the office until they're commissioned. So now we're going to go back and say, oh, all you people have to have a commission. Let's go find their commission. So you would ask the county for their qualification, certificate of qualification, but it's the state that is supposed to have issued a commission based on the receipt of the certificate of qualification. That's for some of them. See, the auditor, they ask for a certificate of qualification. But the clerk of the circuit court, they want a certificate of election. Well, all these are supposed to be elected offices, we thought, but they're not necessarily. But the circuit court, the clerk of the circuit court is. They got a certificate of election. So there's only, when you go through this, there's only 3 offices that have certificates of election. The circuit court clerk, the recorder, and the recorder circuit clerk, because sometimes they combine the offices. So here in Michigan, it'd be the register of deeds. If that's the way it's done. Yeah, certificate of election. And then the state's attorney needs a certificate of election. So we're going to be asking the Secretary of State, right, for all the commissions that were issued to the county officers of the County of Kane. Kane County, or by any other name, whatever they're going to call it. And if they don't have a commission, they're not holding the office. And we're just going to keep pointing it out to them. You're not holding the office, you don't have a commission. Right? And if the Secretary of State says, well, we don't have one, well, then I need a certificate that says they don't have a commission. That there is no commission for blah, 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 County of Kane. Well, that's great stuff. Okay. Good. Okay, hang on a second. Okay, back to court cases. So this is a sister. Kenya sent this to me last week. Right, she's looking at 4 years in prison for being on the wrong end of the stick when the mortgage, when the mortgage bubble burst. I guess we would call it, whatever that was. And you can see now. I mean, that. Whoever they are, that actually run it, set all these other people up to take the fall whenever a fall has to happen. And, Kanye was in one of them, that she was set up to take the fall. Right off the bat, United States of America, that is not the government. The United States of America. T-H-E, capital T-H-E. Actually just capital T. the United States of America. Go look at your money. That name, the United States of America, is the government. This isn't the government. So you can't be charged for a federal crime by somebody who's not the frickin' government. The government isn't charging you. The United States of America is, whoever the hell that is. Right? So that's the first thing that's wrong. And, capital letter name, Kenya Coleman, that's not her name. These are things we pointed out before, but the biggest ones is, I'm not really so concerned about what they said. I want to look at what they did wrong. And what they did wrong is it's not the frickin' government. So this is a simulated legal process using color of law, and that's a civil rights violation. That's really all I need to know. But because we can, we'll know just a little bit more. And we'll go down here and we'll look to see. Right? So here's these people's names. I went ahead and I got all these off of here. Where did I do that? Okay, right. So as we're looking at this here, it's got this Melinda Haig, Miranda Kane, and I don't know who else. Somebody down here, Stewart. But when you go to the bar website, it's not Melinda Haig, it's Melinda Lee Haig. Right? That is the name that is registered to practice law. So she's not using that name on here, so she is not here in her official capacity. She can't be a United States attorney because Melinda Haig couldn't be an attorney. Melinda Lee Haig is the attorney. Miranda Kane is Miranda Beth Kane. She's the attorney. Kelsey Stewart is actually Kelsey Ann Stewart. She's the attorney. And then they had court-appointed defense for Kenya, and Edward William Swanson is the name, not Ed Swanson. And August Paul Gugelman. Right? So this is what I'm talking about, right? The full name. August P. Gugelman. If he signed a piece of paper, August P. Gugelman, well, then he didn't do it in his official capacity as an attorney. And an attorney is an officer of the court. He's a public officer, and that would be misconduct. And that would be big, big no-no. And as it turns out, Swanson and McNamara, LLP, could be licensed to practice law if they had done it properly, but of course they didn't because they don't do anything properly. That's the point. You're never really in court. Okay, so this is who should be on this paperwork, and this is who is. And so that's all you need to point out, right? That the attorneys were not in their official capacity, and the plaintiff is not the government. And so this is a simulated legal process using color of law, and that's a civil rights violation, and it's against the United States Constitution, and, start ripping through them. What I did, I'm going to write this for, okay, we're going to try this, right? So because they did appoint an attorney and an attorney firm to represent her, well, no, as her counsel, right? They appointed them as her counsel, not to represent her, as her counsel, to give legal advice. So, we're going to direct it to Edward William Swanson because he's, one of the partners. I am, whatever her name is, appearing in my proper person, informing Edward William Swanson, whoever your attorney is, an attorney licensed to practice law, and their license number, that you and all your partners of your firm have been appointed as my attorney, and I demand you defend my good name. Edward William Swanson, in your official capacity as an officer of the court, take judicial notice that my fundamental rights and liberties guaranteed by Constitution and treaty have been violated, and your firm's appointment as my defense counsel establishes your fiduciary duty to me to see that I receive a complete remedy and equity, and those responsible for the malicious prosecution of my person answer for their crimes. Your express consent to be governed by the Supreme Court and its rules, procedures, summary judgment, and orders compels your compliance. However, if necessary, I will have the Solicitor General of the United States of America compel compliance as he sees just. The plaintiff in whatever the court case number is not the government of the United States. Take judicial notice of the organic laws found in the Articles of Confederation. Article 1. The style of this confederacy shall be the United States of America. The United States of America is not the government. Proceedings are not in accordance with federal rules of criminal procedure. The attorneys involved are not in their official capacity and therefore are engaged in the unauthorized practice of law. Unless the company has followed the Secretary of State's registration requirements, all partners shall be jointly and severally liable. If you are unable or unwilling to provide me a complete remedy in equity, including the elimination of all civil disabilities, I am left with no choice but to take my grievance to the gatekeeper of the Supreme Court of the United States for his help in obtaining a writ of certiorari and superintendent control from the highest court in the land. That's about as far as I got. I hadn't quite finished it yet, but that's the idea, right? Not pointing out a lot of laws anymore, not a lot of bullshit. Just I'm going to take it to him. He's a partner in this firm, and the firm has been appointed her attorney, right? Because notice to agents, notice to principal, blah 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 blah, and they have a fiduciary duty to defend her rights, and it's not the government. And there's your evidence. And I got to put something here, I think, about where I was talking about the attorneys. The attorneys involved are not in their official capacity. I guess I put in there as their name is not as the name they use is not as it appears on the State Bar of California website, whatever it's called. Anyways, there'll be another sentence thrown in here, and tell these guys they got 72 hours to to give Kanye a remedy, or we'll send it to we'll send a complaint to the Solicitor General of the United States of America. But it would be easier if you could just send it to these guys, just one letter, and be done with it, right? That's to me is be the excellent thing. I'm just going to send it to one place and have them take care of it. And why? Well, because if you don't, you're asked to go into prison. So now here's another thing. When you see like Swanson and McNamara LLP, this is supposed to be a limited liability partnership, and if it was done properly, it would be a proper organization style for an attorney firm. But if it's not done properly, then it's no longer a limited liability partnership. It's just a general partnership, and all partners are jointly and severally liable. So if this firm was to be found in criminal contempt of court, then all the attorneys in the firm would be found in criminal contempt of court. That's how she rolls. And this particular one isn't. And if I can find the paperwork quick enough, I'll show you why. Let me see if I can find it. Okay. So this week I asked Kanya if she could get a hold of the State Bar of California to find out if this company, Swanson and McNamara, had been registered with the bar. And so she emailed them, and they were quick. Man, a couple hours later said, hey, this is what they sent me. And what this shows is that rotate. All right, there's a certificate of registration. Is registered as a limited liability partnership. However, the date is from 2009. It's like, well, that's like a long time ago, right? I wonder if they're supposed to maybe do something once in a while. And of course they are. So, right, this all shows what they had on file. Long story short, is a bunch of stuff from 2009. Right, 2009. Limited Liability Partnership Amendment to Registration from 2009, and they changed the name from one name to another. It was Swanson, McNamara, and Harper, LLP, or Haller, and somehow Haller is gone, and now it's Swanson and McNamara. Okay, so they, I guess they could say, well, at one time they were, but are they today? Let's go look. So one of the things is application for issuance of certificate of registration as a limited liability partnership. So when you go read about becoming the companies, you got to fill this form out to be a limited liability partnership. And on the second page, it talks about having a Secretary of State certification. Attach the original certified copy of the Secretary of State's registered limited liability partnership registration. The form is available wherever it is. Yep. And attach the original certified copy, including the cover with the date stamp of the Secretary of State's form. But they want the certified copy of the Secretary of State's certification. And so when you go to look this company up online, the Secretary of State, they're not on the Secretary of State's website. The name of this company isn't on there. Application for issuance of certificate of registration as a law corporation. Right here, Secretary of State certification, California Law Corporation, attached an original certified copy of Law Corporation Articles of Incorporation. Or yada yada yada. So, but they're not on the Secretary of State's website. There is no company called, what are they called? I don't remember. Right here, Swanson and McNamara. So in the rules where this stuff comes out of, because here's Programs and Services, Attorney Members, Law Corporations, Chapter 3 of whatever this is, it says things like this, that they have to submit an annual renewal with required fee. That only under the name certified by the Secretary of State and approved by the State Bar. Well, they don't have a name under the Secretary of State. Swanson and McNamara you can't find it on the business lookup. A limited liability partnership must annually renew its certification as a limited liability partnership by submitting an annual renewal with the fee set for form forth in the schedule charges deadline. And that's with the State Bar, right? These are State Bar rules we're looking at here. A limited liability partnership that fails to submit a complete annual renewal and fee is suspended and loses its status as a limited liability partnership. So where where this place may have been, that's why we're going to tell them take judicial notice that Swanson and McNamara LLP, they no longer appear unless Swanson and McNamara LLP has filed the Secretary of State's registration requirements. All partners shall be jointly and severally liable. And they haven't. I don't need to point that out to them. They're going to know it. At this point, I'm just trying to get this court case to go away for this woman because she's looking at 4 years in prison. Right? For a simulated legal process using color of law against her, and that's a civil rights violation, and somebody else ought to go to prison for it. And I want the attorneys to do it because they took an oath to do this kind of stuff. They're supposed to police their own. Rule 8.3 of their conduct says if they know another attorney is involved in misconduct, they have a duty to point it out. And if they don't, then they have a problem. Okay, I think that might be about it. I had one more piece of something to show you, but you know what? I forgot what I was going to go look for. It's been a little bit of time. May seem like it was just instantaneous, but no, I've been gone a little bit. But I do want to read a little bit out of Blackstone, Book 3, Chapter 4, which is about the courts of common law and equity in England. And so, Chapter 4, the county court is a court incident to the jurisdiction of the sheriff. It is not a court of record, but may hold pleas of debts or damages under the value of 40 shillings. Very small trifling debts or damage. Or, in other words, other things that there is no controversy. There's a controversy, then you can't have it in this court if you're trying to get debts or damages. Because damages come out of courts of law, and I think debts would come out of courts of chancery. So those would go to the other courts unless they're under 40 shillings. Over some of which causes the inferior courts have, by express words of the statute of Gloucester, that's the very first statute that's in the statute book, I think it is, like 1270, a jurisdiction totally exclusive of the king's superior courts. Right? So this isn't in the king's, not part of the king's bench, not part of the exchequer, not part of the court of chancery, and not part of the court of common pleas. It's got a jurisdiction totally exclusive of theirs. And that's really what the Admiralty Court has a jurisdiction separate from those, because the idea was it wasn't going to be in England. It was going to be out in the harbor someplace, other harbors. For in order to be entitled to sue an action of trespass for goods before the king's justicars, so in the king's courts, the plaintiff is directed to make an affidavit that the cause of the action does really a bona fide amount to 40 shillings, which affidavit is now unaccountably disused except in the court of exchequer. In other words, if you wanted to go before the king's court, you had to put in an affidavit and prove your claim, and apparently in this county court, you didn't have to. One of Elizabeth's statutes, and real quick, just if you don't think this applies, Roe had found a statute in Illinois that all the way back to King Henry VIII all apply, unless they've been repealed by something else. So the statute of 43 Elizabeth, which give her the judges in all personal actions where the jury assesses less damages than 40 shillings, a power to certify the same and abridge the plaintiff of his full cost, was also meant to prevent vexation of litigious plaintiffs who, for purposes of mere oppression, might be inclinable to institute suits in superior courts for injuries of trifling value. So they put in a statute to keep them from going to the state court, the superior courts. Apparently. The county court may also hold plea on many real actions and for all personal actions to any amount by virtue of a special writ called a justices. I went to look for that, and I didn't find this yesterday, but I think it's a summons. But I don't know what it is. A special writ called a justices, which is a writ empowering the sheriff for the sake of dispatch to do the same justice in his county court as might otherwise had been had at Westminster. Right? A summons that the sheriff serves. Right? So normally it could only hear pleas up. So we started out, it could only hear pleas up to 40 shillings. Well, now it can hold pleas up to real actions and personal actions to any amount by virtue of this special writ. And of course, they don't do the writ properly, so they're not really using the writ, but it's that idea. The freeholders of the county are the real judges of this court, and the sheriff is the ministerial officer. So to me, it sounds like we are talking about grand jury. However, it could be the coroner's jury in another court that has a jury. The grand jury is for criminal matters, and the freeholders jury is probably the inquirers of the of the coroner's court. The great conflux of freeholders, which are supposed to always to attend at the county court, justice court for the people and theater for the county's power. Right? So the freeholders are supposed to always attend to the county court. It is the reason why all acts of parliament at the end of which session were wont to be published by the sheriff. Why all outlawries of absconding offenders are there proclaimed, and why all popular elections which the freeholders are to make, as formerly of sheriff, conservator of the peace, and still of coroners, vendors, knights of the shire, must ever be made in full county court. There's something going on in your county once a month that you don't know about, right? And that's where the full county court is. You'll find all the freeholders. That's where all the people who actually run the county, the limited number there are, because you're not a freeholder. You'd like to be a freeholder, but you're not. You don't have fee simple title on your property because the damn title company's holding the title. Well, that's what I want to look for, your title insurance. Go look at your title insurance paperwork. If you have it, and you'll see all the things that it says that it covers. And so the idea is when we find out who this right person is, these are one of the things that you can have reviewed by the court. So anyways, by another statute, no county court shall be adjourned longer than 1 month, consisting of 28 days, and this was also, so they're doing whatever they do on a 28-day basis. That's when you'd know you're looking at the right organization. Adjourned, no county court shall be adjourned longer than 1 month, consisting of 28 days. All right? So every 28 days, this court has to be in session someplace, and all the freeholders are supposed to attend. Where do you see all the cars parked? I wonder what they're doing there. You know, that's a possible place to find the county court. And this was also the ancient usage as appears in the laws of King Edward the Elder. Let the sheriff hold full assembly of the people about once a month, declare the law to every one, severely determined suits. This is probably some religious cult that does this now, right? I don't know who they are, but they were getting together once a month to hold court. And in those times, the county court was a court of great dignity back in the day and splendor. The bishop and the alderman, the earl, with the principal men of the shire sitting there to administer justice both for lay and ecclesiastic causes. But its dignity has much been impaired when the bishop was prohibited and the earl neglected to attend it. And that's what happened when the Norman Conquest came over. They kicked the bishops out of the county court and they put their baron in, and the baron is a Jewish magistrate. And then the earl quit going. And in modern times, as proceedings are removed from hence into the king's, as proceedings are removed from hence the king's superior courts by writ of prone. Okay, so if you're in this lower court and you want to have it removed to the king's superior court, it was by a writ of pone, or recorder. In the same manner as for hundreds courts and baron and courts baron, and as the same writ of false judgment may be had, and nature of a writ of error, it was occasioned the same disuse to bring actions therein. Oh, and then they quit, and then so they quit telling us that, hey, you could go put in a writ of pone, or whatever it's called today, or a writ of false judgment, whatever it's called today, or a writ of error, whatever it's called today, if you were in this lower court, to have it removed to the king's bench. And that would be take judicial notice that you're requesting a judicial review, because that's what a writ of certiorari is. Origin of the writ of certiorari. Present passive to search. Let's see. Generally, a writ of certiorari was used to furnish court with records from another court or tribunal. It was a royal demand for information. They can't not do it. Right? Originally meant we wish to be informed. First appeared in 1272. This way, cases and records might be moved from the local courts to the king's bench or the common pleas, or in between the two courts. So either the Supreme Court or the Circuit Court of Illinois, or whatever it is, Circuit Court for the 16th Judicial Circuit. So my point is, we've been trying to go all the way up to the top, and I'm thinking if we went to the chief judge and asked for a judicial review in the form of a writ of certiorari, or whatever the proper term is today, please look at this case, Judge, because she did an administrative review. We want a judicial review, and she could have if we had asked for the right thing. That's what a writ of certiorari is. Furnished court with records from another court or tribunal. Well, she reviewed it, but she didn't act on it, right? So, from the 14th to 17th century, the purpose of the certiorari seems to have been to supervise proceedings of specialized inferior courts like admiralty, forest, etc., to obtain administrative information. Well, that's really what we did. To bring before Chancery or the court's various documents, and remove coroner's indictments to the King's Bench. You see, the coroner, I think he said that we're all presumed dead because we've never appeared in the last 7 years to collect our property, so we're dead. So you go to the chief judge, and Roe was told a long time ago that the chief judge of the county had jurisdiction over all property in the county. And instead of arguing with it, we're going to go ahead and use that to our advantage and say, well, that's fine, but I claim that as my property. You can have jurisdiction over that other property, but this is my property. And now you can protect my property. This later expanded into reviewing actions taken by statutory bodies which acted in a judicial function. So you can have the same person look at a administrative matter. And she called it administrative review. The discretionary nature of certiorari was and still is a significant characteristic. The writ was granted by grace of the king. However, it appears by 1414 the writ was granted very much as a matter of course upon application of an official. Got to ask for it. But but I don't think. Well, this is saying you don't go to the clerk of the court. You send it directly to the chief judge, to their chambers. In fact, I found something yesterday that it won't be in here, and that is what it says to do. To the justice's chambers. But it wasn't talking about a particular court. This was like a generalized thing I was reading. So, who were they talking about? Well, I say it's the chief judge until proved different. Or it's the presiding judge of the county. Could just as easily be him. But you know what? You just send it to all the chief judges that you can find. Hell, send it to the chief judge of the Supreme Court. I don't care who you send it to. Just send it to somebody. See what they say. After the conquest, the writ of certiorari was soon employed to move cases and records from the various local courts, such as shire, hundreds, manorial courts, to the royal courts. And again, the reason for that is when the Normans came over, they brought the Jews with them. They put the Jews in charge of the local courts because they wanted to use movable property. I'm trying to think of a better word for it, but I think that's what it's called. Right? They wanted gold to be. They didn't want to get rent in kind, right? They wanted to get rent in coin. And so the Jews had this system figured out of, using gold for money. And the idea of lack, and that's how you control it, is by how much there is available, and so forth and so on. And anyways, they took over the courts. They started taking everybody's property, and so the church said, "Well, the answer to this is we need to come up with a way to get it back into the royal court to at least look over, review the finding from the below, and to move business to royal courts. The writs of pone, praecipe were used." And from which writ a certiorari evolved. The principle of certiorari is indeed very old in our law. It is in essence little more than a development of the ancient pone. Right? So if you like common law, well, then use this common law. The writ was used to attain records from a court. Escheators, coroners, chief justices, treasurers, barons of the exchequer, manors of boroughs, and the clerk of the common bench. The writ of certiorari, unlike most of the writs, has hence rarely addressed to the sheriff. Originally, of course, it was used to execute the direct orders of the crown. Right? It's used to orders of the king. Beautiful. The writ was in use from about 1280. A case in 1326 indicates connection between certiorari and habeas corpus. So let's think about that, right? So you want to ask, if you got somebody, a loved one in court or in jail, you want to send for a writ of review of the case to the chief judge, pointing out that the attorneys involved were not in their proper person, and this is a simulated legal process using color of law, and that's against constitutional and treaty law. Something like that, and just see what they do with it. You can add as much more as you want, but if you want me to tell you what to write, I'm not going to do it. I can't do it, right? I mean, I can give you some ideas, but you put something on paper, send it to them, see what they say. A writ of certiorari has been issued to ascertain the cause of arrest of a man called Henry. Right? Why was he arrested? Forget the habeas corpus. Why was he arrested? By what authority did they bring the charge? Throughout this time, certiorari was used as a means to solidify the central government and also to establish the king as the font of justice to rectify wrongs done to his subjects by the common law. The common law was wronging his subjects. In the same vein, however, certiorari was used as a vehicle to allow suit against the government. By the 13th century, certiorari was used specifically for reviewing errors, proceedings, and error developed in parallel with certiorari. Certiorari was wider than a writ of error, as it could be addressed to judicial tribunals, but also could quash convictions. You're already in jail, you need to use certiorari. But you're really not convicted, so, what else? Whatever else it could do. Right, it's the review you want to ask for, because it's the one that has the widest parameters of things it can address, for lack of a better term. Before 1500, through certiorari, the King's Bench could use the writ to quash criminal judgments, as the writ was used to review indictments. Right? You can have you're either still in court and you want to look at the indictment, or you're already in jail and you want to look at the case. Towards the end of the 16th century, the procedure for procuring records and reviewing them was extended to administrative bodies. Beautiful. In a sense, this can be seen as a seed for administrative or judicial review. This review was well established by the end of the 17th century in issues such as licensing. Right? Are they licensed to practice law? Let's find out. Please review the records. The review power was limited, however. Purely ministerial decisions, which did not have a judicial aspect, could not be reviewed, and an issue could be examined only for ultra vires. There was no new trial. For example, in Gardner's case, it was decided that summary convictions tainted with irregularity could be removed into the King's Bench and quashed. Blah, 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 blah. I don't want to read this whole thing, but it was most frequently used to remove cases. For some reason, it was believed that an impartial trial could not be had. I think we'd all agree we're not getting that. Development of administrative bodies, which were brought under judicial supervision of certiorari, through relaxing the concept of record, because all they're really asking for is let us review the record, and they'll make a judicial determination based on the record. Certiorari is a prerogative writ and played part in the struggle between the king and the parliament, or common law and equity. Common law is the parliament, equity is the king, as did the writs of mandamus, prohibition, and quo warranto. These were never writs, whatever they were. The Star Chamber used writ of subpoena, which was an offspring of the writ of certiorari. In 1389, the subpoena used the form of something, which is classic formula of certiorari. A bunch of Latin I'm not going to read. Examples. Okay, that's enough of that. Okay, what was that statute of Gloucester? Because that's important. Proclaimed in August 1278 as crucial development of English law, the Statute of Gloucester and the ensuing legal hearings were means by which Edward I tried to recover regal authority that had been alienated during the reign of his father, King Henry III, who had made a virtual tool of the baronial party led by Simon de Montfort. And so what he's saying here is that when you alienate something, you split the title. Split the title, the reign between the king and the barons. And again, the barons were that's the Jews. And this all happened in 1278, and by 1299 they said that's enough. We're going to kick them all out. Expulsion of the Jews, 1299. And by that time they owned like 35-40% of the England because of this damn thing about this using gold as money. No different than the system we have now, where we don't use gold as money, but you go get a loan, they print the $1,000 for the loan, but they don't print the interest. So there's never enough money to cover all the loans, so people have to lose their property. Statute 1278 provided several important legal amendments, including modification of novel de sin, one of the most popular forms of actions, recovering land which had been seized illegally. It challenged baronial rights through a revival of a system of royal justices go on tour throughout the land, and through a significant increase in the number of pleas a quo warranto, by what warrant, by what authority. Right, so that's when they started using those. It's the first statute recorded in the statute roll. Okay, so just a little history on where all this stuff came from. So it ain't like it happened yesterday. We're talking 1,000 years they've been using a writ of certiorari. I'm sure the judge knows what it is, and you just want them to take judicial notice that you're asking for a judicial review of whatever the issue is. And while we're looking at court cases now, this could be take judicial review that I say I own my birth record and the county court won't give it to me because the county's got the record. So bring it up to the state court and say that it's yours. Or that the county won't allow me to register in the proper jurisdiction so I can register my natural and legal person and claim my domicile, and then be seen with a sui juris legal personality. So, okay, that's enough of me yakking. Again, don't everything I said in this is just me yakking. I don't even know if it's 100% correct. In fact, I'm sure that it isn't, but that isn't the case. It's just what was said this week, and right, we'll work on the details later. But something's happening. We'll see ya. Take care.